All right, we're going to go ahead and get started. Good morning to everyone, and I call the hearing to order. I want to thank the witnesses on both panels. We will have two panels today who are testifying, and we certainly appreciate their attendance and participation in this important subcommittee hearing. Although the health care law won't be fully implemented until 2014, businesses are already feeling the effects. A study released this week by the National Federation of Independent Businesses found that small firms are worried that the law could lead to higher taxes, more administrative burdens, and bigger budget deficits without lowering costs or making Americans healthier. Under the law, many small business owners will be required to offer coverage to their employees or pay a penalty. And the small business tax credit that has been touted to offset the cost of health insurance is, in reality, a temporary and a narrow one, where the full credit applies only to the smallest of businesses. If your firm has more than 25 employees, you are one of the 23 million self-employed, you qualify for no credit whatsoever. We have heard small businesses are concerned that regulatory requirements on insurers such as the medical loss ratio may drive some carriers out of the market, resulting in fewer options and premium hikes. Small firms are uncertain about whether they will be able to continue offering coverage. If so, at what cost, and if not, what their penalties will be and what the coverage will cost taxpayers. This is all while our economy is still very fragile, an economy that is adding fewer jobs than forecast and still has a high unemployment rate. In this environment, it is not surprising that small business owners continue to be hesitant to create jobs, expand, or invest, and there are more regulations ahead. During the healthcare debate, one of the most repeated assurances was that if you like your current healthcare coverage, you would be able to keep it. However, for a number of reasons, a small business may be driven out of its current plan. The Department of Health and Human Services predicts that over half of all employers and up to 80% of small firms may relinquish grandfather status by 2013. This means that small business owners and workers may be forced to switch to a higher price plan or drop insurance altogether. Although the goal of the healthcare law may have been to make healthcare insurance more accessible, its taxes, mandates, regulations, and administrative burdens are causing many small businesses, our best job creators, to postpone hiring and expanding. Again, I thank the witnesses who are here with us today for participating. I look forward to hearing their input on how we can help to reduce the impact of some of the healthcare law's uncertainty, mandates, regulations, and requirements for our small businesses. I now yield to Ranking Member Richmond for his opening statement.
Thank you, Madam Chairwoman. Thank you for yielding. Today's hearing will focus on the health insurance landscape for small businesses since the passage of the health care bill. Currently, employers are the principal source of health insurance in the United States, providing benefits for more than 158 million people. Given the role of business in providing insurance, two questions have been raised about the Affordable Care Act. First, will small firms be able to keep existing health plans? And equally important, how will the Affordable Care Act affect small firms' decisions to offer coverage? These are the questions we will address today. Small businesses face numerous challenges when choosing a health plan. This includes making tough choices about coverage benefits, which physicians should be part of the insurer's network, and what copays should apply to services. Yet, with all these challenges, costs remain the greatest barrier to coverage. According to one report, over the last decade, health insurance premiums have increased 113%. The Affordable Care Act was enacted to lower costs and create more quality health care choices. Still, the legislation has not been without its critics. Some have argued that small firms will not only lose their ability to keep their plan, but most will drop coverage altogether. We will hear from the administration and witnesses on both of these issues. One On the matter of retaining current health plans, CMS has issued regulations outlining how firms can maintain so-called grandfather status. The regulation provides latitude for firms to make changes because of rising prices. It also clarifies for firms what they need to do to keep their plan despite ACA changes. While protecting small businesses' ability to retain plans is important, the reality is many firms will make changes. Historically, small firms change plans due to rising prices or different benefit needs. Now, small firms will be afforded better service and choice when choosing a new plan. The Affordable Care Act not only creates new incentives, but maintain laws that encourage employers to purchase insurance. Most notably, the employer-provided benefits remain tax-free and employees can still pay premiums on a pre-tax basis. And since 2010, small firms have been eligible for a new health insurance tax credit. One of my constituents, Ms. Verna Williams, owner of NOLA Healthcare, LLC, provides a great example of how firms are using this successfully. She owns a private health clinic in New Orleans and was able to avail herself of the new tax credits. Now, all 12 of her employees have health care coverage, and she said she was very pleased with the new health care legislation and its benefits for her employees. In addition to the incentives, insurance reforms are already on the books that benefit small firms. No longer can insurance companies discriminate based on pre-existing conditions or raise premiums without adequate justification. Again, starting in 2014, private health insurance exchanges will create a virtual market for buying insurance. Exchanges will provide another option and enhance competition, something lacking in the small group market. With all these changes, what will all these changes mean for small businesses? One study predicted that employer-sponsored insurance could shrink by over 20%. However, others, such as those by the Rand Corporation and the Robert Wood Johnson Foundation, found that small firms would increase coverage. This hearing will give members of the committee the opportunity to discuss the Affordable Care Act and its implementation. Ensuring that small firms can keep their plan while making coverage more affordable is critical. I want to thank Director Lawson and the witnesses that have taken the time out of their busy schedules to be here today. I look forward to hearing from all of you all. And with that, I yield back, Madam Chairwoman.
Thank you, Mr. Richmond. And as you can see, some of our other committee members have not arrived yet, but I will state for the record that if they have any opening statements, they can submit that for the record. I'd like to take a moment just to explain the timing lights. You will have 5 minutes to deliver your testimony. The lights will start out as green. When you have 1 minute remaining, the light will turn yellow. Finally, it will turn red at the end of your 5 minutes. And I ask you to try to adhere to your 5-minute time limit. And you have the button there to push to speak into the microphone. Our first witness is Mr. Steve Larson, who is Director of the Centers for Consumer Information and Insurance Oversight, or the CCHIO, with the Centers for Medicare and Medicaid Services. Prior to his current position, Mr. Larson served as Director of the Division of Insurance Oversight at CCHIO. Welcome, Mr. Larson. You will have 5 minutes to present your testimony. Thank you.
Good morning, Chairwoman Elmers, Ranking Member Richmond, and members of the subcommittee. Thank you for the opportunity to discuss how the Affordable Care Act is improving the affordability, the accessibility, and the quality of health insurance available to small businesses and their employees. Providing and maintaining health insurance coverage for employees has been a challenge for small businesses for many years. States have struggled for decades, really, to improve their small group health insurance market, and I know this from my many years of experience as insurance commissioner in the state of Maryland. Small businesses pay significantly more than large firms for the same health insurance policy. Some estimates put that at about 18% more. There are a number of reasons for this. Small businesses lack the purchasing power that large employers have. Administrative costs for insurers in handling small businesses are much higher than for large businesses. Small businesses often don't have the human resources staff to navigate through the difficult process of choosing between health plans. Prices for insurance for small businesses can be more volatile due to the smaller risk pool compared to large businesses. And employees in small businesses are subject to medical underwriting in many states. And so this means that the rates that small businesses are charged can spike if just a single employee becomes very ill. The Affordable Care Act addresses these challenges in the market and helps close the gap between small and large businesses' ability to offer health insurance to their employees. First, starting in 2014, small businesses will be able to reduce administrative costs and pool their buying power by purchasing insurance through the exchanges. The exchanges are state-based, competitive marketplaces for buying private health insurance. Small businesses will be able to buy health insurance through a part of the exchange called the shop. Shops will give small businesses and their employees many of the advantages of large employers have today, such as more choice, more competition, and more clout in the marketplace. These shop exchanges are a one-stop shop where small businesses and their employees will be able to easily compare health plans, get answers to questions, and then enroll in high-quality health plans that meet their needs. Health plans that participate in the state exchanges will compete for business on the basis of price and quality. And this type of market competition has the power to drive improvement in both plan quality and affordability. We recently issued draft regulations which will provide states the flexibility to provide small employers with a range of options on how the employers offer coverage to their employees. For example, a small business participating in the shop exchange may choose a level of coverage and a level of contribution toward that coverage, and then employees will then choose among the health plans available on the exchange within that level of coverage offered by their employer. Or employers may provide to their employees a broader range of options, such as shopping for any level of coverage among competing health plans. Under the proposed regulations, the employer would write a single check to the shop, reducing administrative burdens. The shop, as a premium aggregator, would handle the administrative functions that can burden the small business owner. Shops will simplify the employee decision-making process by providing side-by-side comparisons of health plans' benefits, premiums, and cost sharing. Not only will the Affordable Care Act benefit small employers by enabling them to pool their buying power, it will also protect them from premium spikes caused by an employee's illness. Beginning in 2014, the ACA prohibits new health plans from rating on the basis of health status or claims history. In addition, the law limits how much insurers can increase rates based on employees' ages. These new rating limitations will help make small businesses' health insurance rates fairer, more predictable, and easier to understand. In addition, limits on health plans' medical loss ratios will also save small businesses money, as insurers that fail to meet the MLR standard will provide rebates. Finally, the law established a small business tax credit that's making health coverage more affordable for small businesses. The tax credit is designed to encourage both small businesses and tax-exempt organizations to offer health insurance coverage to their employees for the first time, or to maintain coverage that they already offer. Small businesses are already benefiting from the Affordable Care Act, and those benefits will expand dramatically as the ACA continues to take effect. Thank you for the opportunity to appear before you today to discuss the Affordable Care Act's critical provisions to support small businesses' ability to offer health insurance to their employees.
Thank you, Mr. Larson, and I'll begin the questioning. Generally, grandfathering should allow you to keep the coverage you had when the health reform law was enacted, with some exceptions. The June 17, 2010 and November 17, 2010 rules on grandfathering list several changes that disqualify a plan from being grandfathered. The rules seem to leave open whether other changes will be disqualified and leave open the possibility of additional administrative guidance. To explain how plans must comply to continue to be grandfathered, I'm wondering, how can small businesses count on grandfathering if the guidance is vague and the rules may change as we go along?
Sure. Well, as you point out, we put out the initial interim final rule back last summer, which laid out kind of broad categories in which small businesses and health insurers have flexibility to alter some provisions of their health coverage, but not so much that it really changes the fundamental nature of the coverage. We received and have reviewed various comments on many aspects of that regulation. We did, in fact, amend the interim final rule to provide actually more flexibility to businesses and small businesses to maintain their existing coverage by allowing them to, for example, switch carriers if they wanted to switch carriers, if they thought they could get a better deal. So, in fact, although we have amended the initial guidance that we put out last summer, we've done so in a way that really provides more flexibility to small businesses and to the health insurance issuers that provide that coverage.
I have another question for you this time. Small businesses are concerned about the possible mandates in the health care law's minimum essential benefits package. Because many new services, treatments are likely to be required, the cost of premium is also likely to increase. What can you tell us about the Institute of Medicine's forthcoming recommendations on the essential benefits package?
Well, I can't tell you much about what they're going to say. We haven't received their recommendation, but if I could just summarize the process that we will follow. And I would add that we're, I think like you, very aware and tuned into the need to make sure that the package of essential health benefits is an affordable package. There's a kind of a multi-step process that we're following at HHS. The first step was that the Department of Labor performed a survey of employers to gauge what were the typical benefits that are offered in employer-sponsored coverage today, and we've got that survey that's been published. The Secretary also, as you point out, did ask the Institutes of Medicine to recommend to us methodologies or ways to think about how we should define the package of essential health benefits. But I do want to be clear, because I know there's been some confusion on this. The IOM is not the body that will be charged with defining what that list is. That's left to the HHS, and we will do that. And I think we've announced previously that our objective is to have that guidance out sometime this fall. We know there's a lot of interest in that, and both in the states and among businesses and insurers. So we're hoping to get that guidance out this fall.
So basically, you do anticipate that there will be additional administrative guidance on the grandfathering and...
Well, on the essential health benefits, yes. On the grandfathering, I can't speak to that at this point. I don't think we're anticipating anything, but we continue to review these, and as they need to be tweaked and improved, if that need arose, then we would look at that as an opportunity.
Okay. I now yield to Congressman Altmaier for his questions.
Thank you, Madam Chair. Director Larson, thank you for being here. Economists like Dr. Holt-Eakin, who we're going to hear from shortly, have predicted that the employer mandate will lead to dramatic declines in employer-sponsored coverage, as you well know. In your view, will most small firms drop their coverage or simply pay the penalty? And what do you expect they will? Do you expect that they'll continue providing health care to their workers? What do you expect the outcome will be?
We do expect small employers to continue to offer employer-based coverage. It's really a cornerstone of our economic system, of our employer-based insurance system. If you look at a number, and I know there are a number of different studies out there, but if you look at, for example, the RAND analysis or the Urban Institute, there are those two, for example, I think predicted significant increases in the offer rate. Not decreases, but increases. For example, RAND predicted that you would see an increase for very small businesses. I think, for example, less than nine or less employees, from about 50% today to about 70% in the future under the ACA. And the numbers were similar for the Urban Institute.
And regarding the medical loss ratio in particular, as you know, the ACA requires insurance companies to spend at least 80% of their premiums they collect on medical care. What will this change mean for small firms? How will it affect the cost of coverage in your view?
Yeah, the medical loss ratio provision of the ACA is a very important and helpful provision to small businesses and individuals, because it applies to individual purchasers as well. It helps to provide value to small businesses when they are paying their insurance premiums by ensuring that issuers are not spending inordinate amounts on administrative expenses. So it drives efficiency in the issuers for the insurance company, and that creates value for the premium dollars that small businesses are paying.
Now, the companies would argue that it doesn't just drive efficiency. They might dispute that on its face, but they also would say that it's going to drive small insurers out of the health insurance market entirely. Do you have a response for that?
We don't think that's the case, and we haven't seen that. I guess I would also hasten to add that the Affordable Care Act specifically provides states and the Secretary with the flexibility to address, at least in the individual market, the medical loss ratio provisions. In the small group market, in fact, many states already had in place medical loss ratio targets. I think there were around 10 that already had an 80%. There were a handful that had less than that. So that was already present in the marketplace, and many insurers were already used to pricing to an 80% level.
Do you envision CMS playing a role in ensuring competition in the market? Were you given that authority under the law, and are you going to do anything in particular?
I mean, when we get to the exchanges in 2014, competition is kind of the cornerstone of what we're trying to accomplish in the exchanges. And we will be working actively with the states as they set up their state exchanges, and to the extent that we're operating a federally facilitated exchange, we will do everything we can to make sure that there's competition among insurers. The exchanges are all about competition among private carriers to the benefit of small businesses and individuals.
And last question, Madam Chair. Since 2010, eligible small firms have had the ability to obtain a health care tax credit. And according to the NFIB information provided to this committee, 1.1 million small businesses are eligible for either a partial or full credit. And while I realize the IRS administers that credit, does CMS have any estimates on employers taking advantage of the credit and how it's lowered their costs?
Yeah, I know that there are varying estimates about both the eligibility rate and the uptake rate, and some of it's survey-based. We're currently working with our colleagues over at Treasury and IRS to get an estimate on what that is. I apologize I don't have it for you here today, but we hope to get that soon.
Great. Thank you.
Thank you. I have a couple more questions for you, Mr. Larson. Small business owners have told us the new law and its regulations are vague, and we mentioned that already, and they don't know what is required of them. For example, many aren't sure if the employer mandate applies if they have employees who are working 30 hours a week or less. If they currently offer insurance to the individual employee, they aren't certain if the new law requires them to also cover the employee's family. How are the small business employers who don't have the benefit to large administrative staffs or outside benefit counselors to advise them to be expected to comply with the complicated law and its numerous regulations? Can you clarify just some of that for us?
Yeah, and that's a very important question, and I think some of the surveys that have done, and although we don't necessarily agree with many of the points that came out in the NFIB report or the McKinsey report, I think one thing that comes through clearly in those is that there still remain a lot of questions among small business owners. Either they don't understand the law, they don't feel they have enough information. And I think that's an important point that we have to take note of, that between now and 2014, we have to continue our efforts to reach out to small businesses and educate them. There are some tools that will be available. For example, in the exchanges, there's a role of these entities called navigators, which are going to help people understand the health care law, understand how to access the exchanges. But there's more work to be done there, and I think there's been confusion, some misinformation, and I think it's something that we definitely need to focus on between now and 2014.
New regulations require insurers to spend 80 to 85% of premiums on direct care for patients rather than administrative costs. These requirements may be difficult for small insurers to meet, driving them out of the market, limiting consumer choice and raising the cost of insurance, which is, of course, as the market decreases, that's always the risk. How can small insurers compete when they don't have the resources or economy of scale to do so?
Well, we're certainly sensitive to the need to maintain competition. Ultimately, the Affordable Care Act provides some flexibility in the individual market, but less flexibility to modify the MLR standard in the small group market. However, again, I think as I mentioned earlier, there were already existing in many states a medical loss ratio standard that at or about the standard set out in the ACA, and I think that provided a benchmark from which carriers, could launch from.
Interestingly enough, very recently, in fact, last Friday, the last Friday edition of the Hill newspaper had a front page article titled, "Healthcare Law Could Leave Families with Higher Costs." The article describes the debate over what the story terms a major provision of the healthcare reform law, which provides that if a worker has employer-based coverage that's affordable for the employee only, the family is expected to take the employer coverage even if it is unaffordable. Is this the correct interpretation, and can you clarify some of that for us?
We're actually looking at that very issue, which is the interpretation of the application of the tax credit to the individual, to the family, and who qualifies it at what point. When an employer makes an offer, is that binding on the dependents of the family members of the employee? We're anticipating in future guidance to clarify this and a number of issues relating to the application of the tax credit and how it works. We put out a first kind of wave of guidance just a couple of weeks ago on the exchanges, and the next phase of that, which will deal with eligibility and enrollment and the application of the tax credit, hopefully will clarify some of those issues.
Okay. And then I have one last question. This also addresses one of the issues that Mr. Altmaier referred to. The tax credit, along the tax credit issue, may apply temporarily and narrowly if the business has fewer than 25 full-time or equivalent employees, making an average annual wage of $50,000 or less. But what about every other small business? What advantages do they have as far as a tax credit?
Well, you're correct in that the tax credit was targeted toward the smallest of the small businesses with, under 9 getting the maximum credit, and you can get up to 25 depending on what the wages are that you pay your small business. One of the reasons why it was targeted, because those were the small businesses that had the lowest offer rates. As you move up to, say, employers with 50 employees, you have offer rates of insurance coverage that can be in the 80 to 90% rate. So the tax credits were targeted towards that segment of the market that was most in need of help in terms of getting the offer. There are still many benefits, as I mentioned, in the Affordable Care Act for businesses that are larger than 25. The rating restrictions are very important. Small businesses, and I know this from my own experience, in many states, small businesses get rated up if they have sicker members, and so that practice is going to go away. That's going to create a lot of fairness and benefit. And then the general benefits of the exchange, much lower administrative costs. CBO found that as well, and that applies to all small businesses, not just those under 25 employees.
Mm-hmm. So you do see some possible changes or flexibility?
Well, there are benefits to small businesses, but you are right. The tax credit is targeted to the smaller small businesses because, again, it was concluded those are the ones that have the lowest rates of insurance coverage for their employees.
Mm-hmm. Thank you, Mr. Larson. I just would like to ask if Mr. Altmaier has any other additional questions. Okay, well, Mr. Larson, I thank you for joining us today to answer our questions and providing your insight on these issues. We will continue to closely follow them and want to work with you and help ensure that small businesses have flexibility and choices in their health care coverage decisions. I want to suggest that Mr. Larson ask a member of his staff to remain here during the testimony of the second panel. And would you please identify, and I believe we've already spoken, so thank you. Perfect, wonderful. Yep. And thank you again, Mr. Larson, for your time. I truly appreciate it. And now I'd like for the second panel to come forward. Wonderful. Let's go ahead and get started. Thank you so much for coming today to be with us for this subcommittee hearing. Our first witness is Douglas Holtz-Aiken. Dr. Holtz-Aiken is president of the American Action Forum. He served as a commissioner of the Congressionally Chartered Financial Crisis Inquiry Commission from 2009 to 2011, and Director of the Congressional Budget Office from 2003 to 2005. Dr. Holtz-Aiken received his BA in Mathematics and Economics from Denison University and his PhD in Economics from Princeton. Welcome, Dr. Holtz-Aiken, and you have 5 minutes to present your testimony.
Thank you, Chairwoman Elmers and Acting Ranking Member Altmeyer. I appreciate the chance to be here to talk about the Affordable Care Act, small businesses, and employer-sponsored insurance. And you have my written testimony, which I submit for the record. Let me just make a couple of points. The first point, I think the overriding one, is that ultimately the ability of small businesses to offer insurance is contingent on the health of those businesses and their ability to grow. And the Affordable Care Act contains many provisions that I think are detrimental to the abilities of small businesses to prosper and grow. There are taxes. The 3.8% investment tax is going to be a direct hit on small businesses. There are a large number of mandates and penalties, and the regulatory implementation, I think, is daunting to any small business. We're in an environment where in 2010, we had a record number of Federal Register pages. That was prior to the implementation of the Affordable Care Act and Dodd-Frank and a whole bunch of other things. So this adds to the regulatory burden. And even some of the so-called help, the tax credit in particular, is structured in a way that penalizes growth. If you add workers, if you pay higher wages, even this temporary tax credit gets scaled back, and it's ultimately a penalty against those who succeed. And so the structure of the ACA is not one that I would call good economic policy to promote growth, especially among small businesses. The second is that the Affordable Care Act is going to raise insurance costs. There's now a consensus that it fails to bend the health care cost curve, which is the fundamental driving force underneath premiums, and small businesses will suffer from that. It has $500 billion in new taxes. Many of them are taxes that are going to go directly to the premium bottom line. My testimony outlines the impact of the so-called premium tax on health insurers. There's medical device taxes. All of these are higher costs in the food chain that lead to higher premiums. That's going to hurt the ability of a small business to continue to offer insurance and lead many of them to elect to drop their coverage and or never offer it to begin with. Third point, I guess, is that this issue that Mr. Altmeyer mentioned with the previous witness, and that's the question of the incentives for employers to drop coverage and send their employers to the exchanges. And there have now been a number of studies, as was mentioned. One I did with Cameron Smith, my colleague, that looked at the pure financial incentives for employers and employees to mutually agree that it would be in their financial interest to provide the insurance through the exchanges, and we concluded that up to 35 million American workers would benefit from this arrangement and that their employers would agree that they should go off the exchanges. The only loser in that is the taxpayer, who has to pick up an enormous tab. A recent paper by Cornell Professor Richard Burkhauser and colleagues comes to roughly the same conclusion. I'm aware there are other studies that say, no, that won't happen. Their leading argument appears to be that, well, it won't happen because we've always offered insurance, but in the face of a dramatic policy change, I don't see why that's a compelling argument. We're now seeing the leading edge of evidence. We have survey evidence from McKinsey, from PricewaterhouseCoopers, and I'll let Mr. Dennis speak for the National Federation of Independent Business, suggesting that, in fact, this financial incentive is not only real, it will be pursued by businesses. And so I think this is a serious concern because the subsidies are enormously generous. We're talking about $7,000 for someone making $59,000 in income in 2014. This is well over 10% of their income. It would be financially irrational for employers and employers to ignore that kind of money. And if it's true that many pursue this, the budgetary cost of the insurance subsidies through the exchange is going to explode. Could be easily double what was in the original bill. We are all well aware of the financial problems that face the United States government, and to have this come in much more expensive than was budgeted, I think, is an extreme danger. Which brings me back to my first point, which is, in the end, it is going to be the environment for small businesses to grow and prosper that is crucial. There is nothing about sailing directly toward a debt crisis that is good economic policy or beneficial for the small business community. At the heart of our debt problems are explosive entitlements, and my view is that the Affordable Care Act has a whole series of upward risks on the budgetary side that make the possibility of that debt crisis much higher, and as a result have to be viewed as a threat not just to the economy but to small businesses in particular, and certainly to their ability to continue to offer insurance to their employees. And I understand the sentiments behind the Affordable Care Act, but I think on balance its structure is one that hurts the small business community and doesn't aid it in the end. Thank you.
Thank you for that, for your comments. And we do have your testimony, and as we do all of our panelists. I now yield to Representative Kingston from Georgia for the purpose of introducing his constituent as a witness.
Thank you, Madam Chair. It's a great honor to be with you on this dais. You and Mr. Altmaier, a good friend of mine from Pennsylvania, and I appreciate all the hard work that you do on this subcommittee to try to promote jobs in this tough economic environment. I appreciate the panel for being here. I have a hard deadline at 11 o'clock with another committee in which I serve, so I'm going to be leaving shortly before then, but I wanted to say hello and introduce my constituent, Brian Vaughn. He is no stranger to the struggles of an entrepreneur. He has been with the Burger King franchise operations since 1980 and kind of came up through the corporate structure working in Florida and in Georgia, and then in the 1990s took the plunge to become a franchisee himself, and since that period of time has bought out his partner and been on his own with his wife. I'm not sure if Cindy's here, but knows the importance of keeping employees happy by offering a good compensation package, including a good benefit package, worker safety, a good environment to work in, and has many employees who've been with him on the management side for over 10 years, which is remarkable. He has 4 stores in 3 different cities and also knows what it's like to compete in this environment and to get the customers back in when it's very hard on their pocketbooks in today's economy, but knows all the challenges that small business people face, really labor, environmental regulations, safety regulations, franchise regulations. I think he's been through it all, but has done it successfully. So I'm very proud to have him as a constituent and as an example of an entrepreneur. And I want to point out also, one of his jobs before he became an entrepreneur was to recruit entrepreneurs. So he looked at it and did not have to take that plunge, yet he made it anyhow. So I'm proud to have Brian Vaughn here today, and I look forward to his testimony.
Chairwoman Elmers, Congressman Altmaier, and distinguished members of the subcommittee, thank you for inviting me to testify before you today on how the new health care law will impact my business and my employees. As the Congressman stated, my name is Brian Vaughn, and I own Nearly Famous Incorporated, which consists of 4 Burger King restaurants in Georgia, and I'm happy to be here today on behalf of the U.S. Chamber of Commerce. I'm also a proud member of the National Franchisee Association and have served on their board of directors for 3 years. Nothing I say here today reflects the position or opinions of my franchisor, Burger King Corporation. You know, when people think of Burger King, they think of a big international corporation. Even though the sign on the door says Burger King, my 4 restaurants are small, family-owned and run businesses. I began working as a Burger King assistant manager in 1980, as the Congressman said, earning $14,000 a year. After working my way up, I partnered in 1993 with Francis Lott to open our own 4 Burger King restaurants in Georgia. In 2001, I bought out my partner's interest, and today I operate these 4 restaurants with my wife, Cindy. At our 4 restaurants, we are proud to have created 182 jobs. We have 59 full-time employees and 123 part-time employees. 14 of our full-time employees are managers for whom we currently pay 100% of their health care premiums at an annual cost of nearly $56,000. We also pay for term life, short-term disability, vision, and dental insurance. My wife and I participate in this very same plan. For our other employees, we offer a Value Mini Med plan at a cost of between $106 and $165 per month. Currently, only 19 of the more 100 part-time employees have elected to participate. Many employees choose to keep the wages they earn to help pay for their day-to-day living expenses rather than use a portion of their wages to pay for the coverage. As the president of my company, I also have to decide how much of the company's income can be used to pay for wages and benefits, and how much has to be used to cover the expense of daily operations. There's only so much money And first and foremost, we all have to cover our daily expenses. Washington, it seems, really doesn't understand this. A lot of noise was made last fall about the types of plans that I offer my employees. Under the health reform law, Washington has decreed that these so-called limited benefit plans are not acceptable. Despite repeated promises that if you like your plan, you can keep it, the law has outlawed these plans beginning in 2014. I understand that for many, a more comprehensive plan seems a critical, and by comparison, these limited benefit plans are slim. However, it's important to acknowledge reality. These plans are less expensive and allow my team members to choose to take more of their wages home and use a smaller amount of their wages to pay for some coverage. Prior to health reform, I had the flexibility to hire more workers, pay them a wage, and offer them access to this moderate coverage. Now I'm being told by Washington that I have to offer all my full-time employees Washington-defined health coverage or pay a penalty. Because of the cost of offering this prescribed coverage and the size of the penalty, I'll have no choice but to restructure my workforce in a way that protects me from losing everything I've worked for. What does this mean? Well, given the law and the unfinished regulations, and I mean unfinished regulations, it's hard to say. I have no idea. Prior to the law's enactment, my goal had been to hire fewer people for more hours. It's easier to retain employees that work full-time. However, now that the law is passed, I have to consider options other than what makes practical business sense. Now, because of what Washington has mandated, it may make more sense for me to hire more people for fewer hours at a time when millions of Americans are out of work. Is this really the right incentive? This is not what I want to do, and it's not what's best for my employees. But in order to survive and be able to pay the employees that I have to, it's what we'll have to do. While I have not read the entire law and I'm not able to follow the regulations, which are being issued at record speed, mind you, I'm trying to figure out how to protect the company that I've spent my entire life building. It's ironic that the law touted as the Patient Protection and Affordable Care Act neither protects patients nor makes health care affordable. Instead, it's a law of broken promises under which no one will be able to keep the health care they have, even if they like it. It's a law which incents companies to scale back their workforces and reduce the benefits offered by their valued employees. In conclusion, I understand that given the existing political realities, Washington, D.C., a total repeal of the health care law by Congress is an unlikely proposition, at least for now. However, I am hopeful that Congress will repair or eliminate the more onerous burdens, such as the employer mandate. These provisions saddle businesses with new requirements that actually encourage us not to expand our business and astoundingly discourage us from creating jobs. The bottom line is that your decisions can help or hinder this. The laws you create can either give small businesses greater confidence and certainty to grow and generate new jobs, or just do the opposite. Regrettably, this new health care law is already doing the latter, and Congress must take the action to rectify it. Again, thank you again for this opportunity, and I look forward to your questions.
Thank you, Mr. Vaughn, and I'll just tell you that my very first job at age 16 was with Burger King back in Madison Heights, Michigan in 1980. So
Thank you.
I am thank you again for your testimony. At this moment, I would like to introduce Mr. William Dennis. Mr. Dennis is Senior Research Fellow at the National Federation of Independent Business. He has directed the NFIB's Research Foundation since 1976. Welcome, and you have 5 minutes to present your testimony. Thank you.
Chairman, Mr. Altmeyer, Representative Kingston. Last week, NFIB released a study called Small Business and Health Insurance 1 year after enactment of PPACA. What I'd like to do is focus my remarks on the results of that study, since it's quite current and I think in many ways relevant to what we're talking about today. First of all, to be sure we understand who was included in this. We surveyed only people that were under 50, small employers that were only had 50 or fewer employees. It was a nationally random sample. It wasn't just of NFIB members. There will be probably some randomly in there, but this is a national random sample. It was done in late April and in May of this year. So it's, well, it's not as wasn't done yesterday. It's current enough so that I think we can say it's the state of what we know today. The findings are really quite simple, I think. The first is that we essentially are in this period of declining offer rates by this series of firms. They're at 42% now, which is the continuing of the downtrend over the last 10 years at least. And our 42% number is not surprising. MEPS just produced one that was 39%, which is lower. And so it really does captivate the trend. Something else that you should understand is that basically nothing has happened in the last year and nothing is projected to happen in the next year. People who had offered before tend to offer now and expect to offer in the future. And those who do not or have not offered didn't pick it up this year and they don't plan to in the future. So essentially what we're seeing is this continual downtrend that's going on and on. The one thing we are seeing, however, is that 20% with insurance expect major changes in that insurance. And virtually all those changes are not to the benefit of the employee. Since enactment, 1 in 12 small employers have either lost their specific plan or been told that they will lose their specific plan. Of those who claim to be familiar with the law or having some familiarity with the contents of the law, they, by very large margins, overwhelming margins, particularly those who employ or those who insure, think it will not reduce the cost of health insurance. It will not reduce administrative burdens, will increase taxes, will add to the deficit. They do agree that more people will be covered, although they're not quite sure about whether that's going to yield better benefit or yield greater health outcomes. There are, I have a whole series of things here, but to begin with the tax credit, let's just look at the tax credit. We estimate, using some new data that we collected that we don't think is generally available, out of the 5,228,000 small employers in this class, an estimated 245,000 will be able to take advantage of the full credit, and 1.165 million will be able to take advantage of the partial credit. That's not how many will. Fewer will probably take, fewer will take advantage of that in part because of knowledge. But that's the maximum that will take part. Now, beyond that, there's the whole incentive effect. How many will it incent? One of the ideas behind this is just not to provide a windfall to have people do what they're already doing. It's to provide an incentive for people to purchase it. Yet we calculate that only about 2% will have an incentive based on the full credit, and more than that will have an incentive based on the partial credit as well. We also got a bit into the idea of will these small business owners, if people start to leave, low-income people start to leave for the exchanges, what are they going to do? And about 21% said they would seriously explore looking at whether or not they're going to drop their health insurance for everybody. Now, and another 26% said that they would somewhat less do that with somewhat less certainty. So there clearly is a tendency, or there is a thought process which would lead folks in that direction, and once competition actually sets in, new firms continue to churn in without health insurance, we're going to see real market pressures not only not to add for those who don't have it, but to lose it for those who do. Thank you.
Thank you, Mr. Dennis. I now would like to yield to Mr. Altmeyer to introduce your witness.
Thank you, Madam Chair, and it is my pleasure to introduce Professor Timothy Jost. Professor Jost teaches at the Washington and Lee University School of Law He is co-author of a casebook, Health Law, used widely throughout the United States in teaching health law. Professor Jost is the author of numerous articles on healthcare regulation and comparative health law and policy. He is also consumer representative to the National Association of Insurance Commissioners. Professor Jost earned his J.D. from the University of Chicago School of Law, cum laude. Welcome, Professor Jost.
Thank you very much, and thank you, Ranking Member Elmers and Congressman Altmaier and Congressman Kingston. The title of today's hearing is Small Business and PPACA. If they like their coverage, can they keep it? This is a variation of one of the commitments made by the Affordable Care Act, realized in Section 1251, that if you like your plan, you can keep it. But notice, the ACA's commitment is to individuals, not to employers. It is not, if you are currently have insurance through your job, you're stuck with that insurance no matter how it changes. It is, if you, the employee or individual enrollee, like your coverage, you can keep it. In fact, most privately insured Americans do have insurance through their jobs, and regulations adopted last summer by Labor, Treasury, and Health and Human Services give employers considerable flexibility to change their plans without losing grandfather status. Employers can change their formularies, provider networks, and even insurers or plan administrators. They can increase deductibles, out-of-pocket limits, and copayments, not only to keep up with medical inflation, but up to 15% more. They can reduce their own contributions to premiums by as much as 5%. They can add new employees and new dependents. Of course, if the plan changes too much, it ceases to be the plan it was. It's probably no longer the plan the enrollee liked, and grandfather status is lost. The Department's projected that 15 to 33% of plans would lose grandfathered status in 2011. Private surveys cited by Mercer and Hewitt in submitted testimony predict higher levels, although they also noted that many employers do not really view loss of grandfathered status as a major problem, and some said they wanted to comply with the new law as soon as possible. The NFIB survey released last week, surprisingly, did not reflect widespread loss of grandfathered status. The NFIB reports that 90% of small businesses intending to make significant changes in their plan have not lost their plan. It does report that 12% of employers have had their plan terminated or been told that it will be not available in the near future. This number is consistent with churn in insurance coverage observed in earlier years, and I believe I cited a 2008 NBER report which showed this kind of turnover in the early 2000s. Plans are always coming and going in the small group market. NFIB also reported that 20% of employers anticipated significant changes in their plans over the next 12 months. But last year and the year before, changes in benefits, cost sharings, and premiums, as reported in the annual Kaiser HRET report, were at even greater levels. This is a bad time in the economy, as we all know, and things are changing. Another and very important question is whether employers will continue to offer coverage after the ACA is fully implemented. A number of studies have addressed this question. Their predictions range at the extreme from those of Dr. Holtz-Eakin, who predicted that ESI would shrink by 22%, and the McKinsey survey, which claims that 9% of employers will definitely drop coverage, to those of the RAND Corporation, which estimated that coverage would in fact grow by 8.7%. But most studies, including studies by Booz, Lewin, Urban, Mercer, Towers Watson, and most importantly the CBO, predict that coverage will not change dramatically once the ACA is implemented. In fact, all of the reason employers offer insurance now will continue to exist after health care reform goes into effect. Most importantly, employee benefits are exempt from federal and state income taxes and payroll taxes. In Virginia, where I live, an employee taxed at the alternative minimum tax marginal rate of 28% receives a subsidy of over 49 cents on every dollar for the coverage that they receive through their employer. The average American covered by ESI has an income of 423% of the federal poverty level and would not be eligible for any of the premium subsidies under the Affordable Care Act. Employers who drop health insurance would have to dramatically increase after-tax cash compensation for their higher income employees to cover this loss of tax subsidy, and the law prohibits them from dropping benefits from their lower wage employees but keeping them for their higher wage employees. Health benefits also continue to be one of the most highly valued forms of compensation. and also help ensure a healthy and productive workforce. After 2014, employees are even more likely to demand health insurance at work because of the individual mandate, and large employers, not small employers, large employers will face a penalty if they don't offer insurance. In Massachusetts, which adopted similar reforms in 2006, employer offer rates grew from 70 to 76%. There is every reason to believe that the ACA will not dramatically change the scope of employer coverage in the United States. Thank you.
Thank you, Mr. Jost. I will begin questioning, and my questions are directed to each member of the panel. Healthcare reform was supposed to make healthcare more accessible and affordable. Do you think the new law does anything to help reduce the cost of healthcare? And I'll start with Mr. Jost.
Yes, and one example of that is the medical loss ratios, which has already been discussed. I follow the medical loss ratios very closely. I was very much involved in their drafting through the National Association of Insurance Commissioners. One of the things that people are beginning to notice is that growth in healthcare costs has been dropping in the last couple of years. There's another report on that out this morning. At the same time, in the very recent past, insurance profits have been growing very, very rapidly. And people who follow the insurance industry closely are saying that if insurers have to spend 80% of their premiums on healthcare costs and costs are dropping, premiums can't continue to rise. They're going to come down. And we already saw that in Connecticut, where one insurer dropped its rates by 10%. We're starting to see it in other states. I think, in fact, that the MLRs is going to have a dramatic effect in reducing the cost of health insurance for employers and individuals over the next couple of years. And if I could just add quickly, one question that was asked earlier was, will it drive small insurers out of the market? I've read all of the state adjustment requests that have gone final. In only one state have any insurers left since the law went into effect. And as Mr. Larson said, people are talking about it. It isn't happening. Thank you.
Mr. Vaughn.
Well, I certainly would have no way of knowing. I'm not an academic. I'm a business person. But let me just give you a few numbers so you can kind of understand my situation. If you take 2010 in my small business, I'm a subchapter S corporation. So at the end of the year, the bottom line of my company was $319,000. If I took the way this plan exists now, if I took this plan and I insured all of my employees the way it's designed, it would cost me $307,000, okay, which leaves me $12,000. Now, understand, I'm taxed personally on the net income of my company, all right? But do I take that money? Absolutely not. What I do, I have to turn that money around and reinvest in the building, buy new equipment, and those sort of things. $12,000 doesn't even leave me enough to pay my taxes, let alone reinvest in my business. So, and the other piece of this is, I'm not likely to pay a penalty. Why would I do that? Because I'm not really helping anyone. And the penalty would cost me as much as the insurance that I'm providing now. So if this thing continues on the path it is, I can tell you right now that I will do everything I can to avoid paying the penalty. I will probably more than likely drop coverage. And what it will do to the cost of insurance, I have no idea. Thank you.
Mr. Dennis.
Oh, excuse me, thank you. One of the things that's really important to remember is that when we started this thing, small businesses were very much in the forefront of calling for reform on health care. And the reason was cost. Cost was driving us nuts. This morning, I believe I opened the Journal and the Wall Street Journal and saw the study was out from the Social Security Administration, which projected that under the plan, under the bill, costs would rise faster than they would otherwise. Wasn't a great deal, but it was indeed faster. That's the first thing. The second thing is we're talking about relatively, recently we've had some lower rates than we've seen over the past several years, and it's been attributed some quarters to indeed the new law. But in effect what we're seeing is in this recovery, very different from the last 5 recoveries, is that the relative demand and the relative purchases, if you will, of various services have been much slower than average. And healthcare has been one of them. Whether it's people not having the money to go, or being more parsimonious and considering it as something that they really didn't need once they thought about it, I don't know. I don't have any idea. But still, the whole thing is that this is a very abnormal period. And then we start looking at everything that's inherent. You're going to have minimum benefits, and while we don't know what's going to be in the minimum benefit package, clearly, as Mr. Vaughn's example shows, there's going to be a whole series of folks that are either going to have to add a lot more or not do anything. Then we have all types of expensive things that we haven't even talked about, which don't necessarily directly affect smaller firms, but some things like the Class Act and all these kinds of things. And then we have, of course, a whole lot of new folks coming on. So all this together is going to drive costs higher, I'm afraid.
Thank you, Mr. Dennis. Dr. Holtz-Aiken.
I would largely concur. In analyzing the bill as it passed and became the law, the CMS actuary, the administration's own actuary, concluded that it would raise, not lower, national health expenditure. If the national health expenditure bill is larger, the insurance that covers that bill has to be larger. There's no way around that. And when the CBO put out its new long-term budget projections, it found that after the passage of the law, things went up, not down. The law contains 2 new entitlement spending programs. The CBO estimates they grow at 8% a year as far as the eye can see. There's no evidence of bending the cost curve anywhere to be found in those kinds of numbers. And so if you dial the clock back to the beginning of the debate, there were 2 criteria by which any health care reform should be judged: the ability to cover more Americans with affordable and quality insurance, and the capacity to deliver those services with lower cost and higher quality. And the Affordable Care Act flunks the latter, which is ultimately the fundamental driver of insurance costs in the United States. And so things like the MLR are mere fiddles at the edges of a tidal wave of health care spending. And unless we get the tidal wave under control, the premiums go up.
Thank you. I have one more question for you at this time. Do you think the health care laws, mandates, and taxes, along with the numerous regulations that are being issued, make it less likely that small businesses will hire more workers and expand their companies? And again, I'll start with Mr. Jost.
Well, small businesses, there are some incentives and disincentives. There are benefits under the law that small businesses get, that large businesses don't get, and there are some benefits that large businesses get that aren't available to small businesses. For example, small businesses need to cover the essential benefits package. It's not clear to me that that's going to be a major expense, because in fact what happens is that state mandates are going to go away, and it's not at all clear the federal essential benefits package is going to cost more than state mandates. But that is something that small businesses need to cover that large businesses don't need to. On the other hand, large businesses need to pay the penalty if they don't cover their employees, and small businesses don't. I come from a family that started a small business about 20 years ago, and my brother-in-law started it borrowing money from the rest of us in the family, and it is today a $300 million publicly traded company, and its product is a household name. They didn't worry about, am I going to get this benefit or lose this benefit if I grow a little bigger? They tried to help out their employees, they tried to help out their customers and sell a good product, and I think that's the way American businesses work. And I think that under this law, it's going to continue to work that way. It's just that employees and individuals are going to have better health care coverage.
Mr. Vaughn.
Well, I can just start out by saying that overregulation is killing small business. Let's just go back to minimum wage. I've already scaled down my staff, and I'm running frankly as lean as I can possibly run right now and make a living. The reality is there are going to be virtually no full-time jobs in this industry. And I can tell you the way it will work in my company is only my management staff will be full-time. Everyone else will work 29 hours a week or less. And it's just that simple. We cannot afford this thing.
Thank you, Mr. Vaughn. Mr. Dennis.
Well, right now, immediately, the overwhelming issue is uncertainty. We have absolutely no idea what's going on, and I think everybody would agree to that. I don't think that That's a very controversial statement. Nonetheless, that has an enormous impact on what you're willing to do in terms of hire and invest. And we're seeing that very clearly within the small business population. We do this monthly survey that we've been doing since 1973, and it's constantly showing that small businesses are much more pessimistic and feel much less how can I say, favorable towards the economy than do larger folks. And that's borne out by, their sentiment is borne out by a whole series of measures, including some that are contained in a recent Federal Reserve of New York paper that's just out. But that's the immediate thing. Longer term, you have the whole issue of cost and taxes, and they go together. And what does that have to do? Well, it simply means that if you don't have it, if the government has it, then you don't have it, and you have less available to do that. And so the question is, you can't invest if you don't have it. And then we have the interesting issue of growth, and does the 50 divide mean anything? And for some firms, it clearly will. And it won't mean just do I go over 50 or not. It's whether I hold back a little bit from 50 for fear that I'm going to be hung up on that whole thing. There will be a lot of firms, excuse me, who are growth firms that, as Mr. Just used as an example of his brother-in-law, that will just go blowing right on by. I mean, they're going to be high growth firms, and they're not going to pay attention to anything. But it is going to have an impact on a whole lot of small firms.
Dr. Holtz-Aiken.
Well, I guess I'd echo the firm level recognition of the regulatory costs that Mr. Vaughn mentioned. I think I'd echo the uncertainty and the firm level growth incentives Mr. Dennis highlighted. But if you step back and look at the basic architecture of the Affordable Care Act, it says, let us spend $1 trillion over the next 10 years and finance that by raising $500 billion in new taxes, much of it on inputs into what will be paid for by insurance, and thus make insurance more expensive. And let's finance the rest by cutting $500 billion roughly out of Medicare, something the CMS actuary has said is simply economically unrealistic and would mean the closure of a large number of hospitals and failure to serve those beneficiaries. So I take that with a grain of salt. What you have in the end, then, is higher taxes, much larger deficits, in a recovery that's utterly unsatisfying, and I cannot conclude that that's going to be beneficial for the hiring practices of small businesses.
Thank you, Dr. Aiken. I now yield to Mr. Altmeyer for questions.
Thank you, and I'm glad that our panel brought up the subject of taxes and the burden that it places on small business. I wanted to ask Mr. Dennis and Mr. Vaughn, as you are aware, currently health benefits for employees is non-taxable, and some proposals have recommended requiring employees for the first time ever to pay taxes on health care benefits. And I was wondering for Mr. Dennis, how would a fundamental change like that impact a small business's decision to offer health care to its workers?
Well, the question is really equity of the whole thing. I mean, right now we've got a system where if I'm an employer and I contribute to $1,000 or $5,000 to help my employee buy their own insurance premium or buy their own insurance on the market, whether it's through the exchange or whatever, there's no tax deduction for no tax exclusion for the employee. Where if it's, if I'm paying for it, there is an exclusion. That clearly is inequitable, and really, I think in the long term, is going to hurt smaller firms and their ability to provide this sort of thing. Is the fundamental inequity involved? I think you're not asking about the inequity, though. You're asking about whether or not the tax itself, is important. And the question is, yep, it does lower the amount that you have to pay up front. Long term now, what it does is it encourages more people to use more services, and more services means higher costs. And long term, we just can't have that. We have to start being more parsimonious on many of these things.
So you're in support of that policy change to tax?
Of making it equity? we would be in support of making it equitable. I am not sure that our organization has taken a position on whether or not they would be in favor of, how they would be in favor of handling the tax exclusion issue.
Okay, thank you. Mr. Vaughn, as a business owner, how would your employees react if they had to pay taxes on the health care benefits that you provide?
Well, that's a hypothetical, and I apologize for really not having an answer to that. I can't predict how they would react, but there's something really important here that I don't want to get lost. Small employers, let's define what is a small employer, what is a large employer. It's the method that's being used right now, and frankly, I can't understand it. And what is a full-time employee and what is a part-time employee, I can't understand that either. There was a study done recently by the University of Tennessee, funded by the likes of Burger King, McDonald's, and different ones, to determine how can we really, what would be the best way to determine what a small business is and what can they afford. Have you heard about profit per employee? As opposed to this very drawn-out, sort of complicated formula for figuring these things out, it's this real simple formula. It's how much money do I make net divided by the number of employees. Guess what it is in my industry? $1,300. If I paid the penalty, it's $2,000. Is that equitable? Does that make sense? I got to tell you, there are other industries, whether it's financial or insurance industries, they're $10,000 plus per employee, profit per employee. So my position is this. This thing has to be repealed. I mean, it has to be repealed. And if it's not repealed, at the very least, the regulatory aspect of it should be changed to a system-like profit per employee. And again, I apologize for not answering it directly. It's just I really don't know how they would react.
But are you concerned to hear that that is a proposal? Is that something, if your representative came and sat down before you and said, hey, here's something I'm thinking about supporting, taxing your employees' health care benefits, you wouldn't?
Of course I would be concerned about that. And it would not, I'm for lower taxes for anyone. Yes, absolutely.
Mr. Jost, do you want to comment on what type of fundamental change like that, the impact would be on the health market?
I think it would destroy our employment-based health insurance system in this country. We have a long tradition in the United States that actually has been very successful in providing health insurance to people through their jobs. We're now trying to get beyond that to reach those people who are not covered through that, and that's what the Affordable Care Act is going to do. But to pull the rug out from under employment-sponsored health insurance by removing the tax deductions and exclusions would destroy it and would throw our health care system into chaos.
Dr. Holtz-Eakin, do you want to comment on that? I'm going to move on to a different question, but you look like you might have something to say.
Well, I mean, there are really two aspects of it I think that bear mention. One is it figures prominently in this discussion about how many employers will drop coverage under the Affordable Care Act, because the basic horse race is between the pile of cash being put out in the exchanges for low-wage workers, where there's a clear net advantage for the employer to drop coverage, pay the penalty, give the employee a raise, let them go use their after-tax wages plus the subsidy and get insurance. And another federal subsidy, which is non-taxation of employer-sponsored insurance, which benefits high-wage workers. And those who conclude there will not be a big employer drop are counting on the fact that tax subsidy for high-wage workers will dominate. Employers will continue to use it to pay their high-wage workers, and the non-discrimination rules will keep everyone in. I think that's an optimistic fantasy, quite frankly. And so, be quite aware that in the end, all you're doing is doing a horse race between two federal bribes, and one of them is going to win, and we'll see how it plays out, but it's costing the Treasury either way. The second thing is, most people who talk about changing the tax treatment of employer-sponsored insurance are looking at revenue-neutral tax reforms that broaden the base and thus bring in subsidized consumption like health insurance in exchange for lower tax rates. And I think that's a very different question than simply saying, do you want to go tax health insurance? It's about having a tax system that is fair across low and high-wage workers and provides greater growth incentives because marginal rates are lower.
Right. Last question. I wanted to give you the chance to answer that because I knew, I thought I would know, I knew what you were going to say.
It was a shocking question.
Right. The question I wanted to ask you, and you are not here to pontificate about politics or to speculate about what the Congress is going to do or should do, certainly. But you bring great credibility to the debate based upon your background and your involvement in the past. So I ask, just out of interest, given where we are, this is the law. The bill has passed. It's the law. The Supreme Court may or may not rule, absent knowing, what's going to happen there. Repeal has failed in the current political environment. We don't know what the future holds there. What would be, to the degree you're comfortable assessing it, what would you suggest the Congress do as far as tweaking the current law, assuming this is a fact, this is going to continue, or continue to push repeal even though it doesn't look like it's a viable option?
Wow. And I have 5 hours instead of 5 minutes? But briefly, I think you can point to a couple of things. There are some provisions of the law that I think have universally garnered some suspicion. I'll use that word. And I think the Class Act is first among those, and probably should go away as something that is ill-designed and dangerous to the American taxpayer. The second would be, in the array of coverage expansions, the heavy reliance on an unreformed Medicaid program, I think many people find problematic. We know Medicaid beneficiaries have much more difficulty finding primary care physicians and seeing specialists. To simply put more Americans into a substandard health care system is problematic. And I have a concern that there's just too much money on the table in the exchanges. I won't relitigate that. So in terms of the coverage expansion pieces, I think you have to look at all that. I won't say a lot about the regulatory initiatives. I think making them cleaner, getting the rulemaking done in a fashion that doesn't leave the business community so perplexed to be entirely beneficial. And then on the delivery system reforms, I think there are two very big concerns. One would be the role of the Independent Payment Advisory Board, which, as structured, appears inevitably to be led to near-term provider reductions as opposed to quality improvements or other things that everyone thinks would be desirable. Just can't get there. It's given one-year targets. It's going to go slash reimbursements, probably on the most innovative and thus most expensive new therapies. That's detrimental for health care. I'd worry a lot about that, quite frankly. And the ACOs appear to be a recipe for industry concentration, not better care. And so, across all of these things, I think there is work to be done on improving the delivery system, improving the financing of the coverage expansions, and making sure that this thing hangs together budgetarily, about which I have deep concerns.
This is really the last question. Are there things in the bill that you think are worthwhile in isolation that should be kept?
I have always been a proponent of exchange-like entities. Forget the label attached to them, but better ability to shop, compare, and pursue health insurance has always been, I think every economist would like that, and I certainly do. So the design of those and the exchange rulemaking, I think, is a critical moment in the life of this law.
All right. Thank you all for being here.
I now would like to recognize Mr. King for his questions.
Thank you, Madam Chair. I thank all the witnesses for being here to testify, and regret my schedule didn't allow me to hear it all in depth. So I hope I don't duplicate anything that has been raised here before this panel. First, I think I need to make a statement as to if anybody wonders where I stand on this issue. And I've looked at it from a whole number of different perspectives. I just don't think it's arguable whether this is sustainable economically, or whether it will improve our health care, or whether it will avoid eventual rationing, or whether it will reduce research and development. I think those things all we understand, at least I think I do thoroughly, that we're not going to see better health care at a cheaper price. It's more accessible or more available. You'll see different people that have access, perhaps, but it's perhaps a shift within the population, but I don't think it changes anything beyond that. Now, so I've spent my life my working life as a small businessman. I started a construction business out in 1975, and we provided, not on the first day because I didn't have any employees the first day, but over a period of time as we began to accumulate employees, I took on a responsibility to voluntarily provide them health insurance. And when I've watched this debate be shifted here in this country, so that the word health care and health insurance those two words have been conflated into the same meaning in the minds of many people that are advocates of this policy that's before us today. I think that was dishonest, I think it was disingenuous, and I think it was willful, a strategic effort to try to blur the definitions. And I remember our then governor of Iowa, Governor Culver, coming to this Capitol in our delegation meeting and saying 40,000 kids in Iowa don't have health care. And I don't know how many times I had to ask him about what that meant before I could get through to him that health care and health insurance were two different things. I'll make the point that I don't believe an employer has, if they choose to accept the responsibility to provide health insurance for their employees, that's a competitive position in the marketplace, but it's not a moral obligation for the employer. To hire good people and keep good people is the motive. When the federal government decides to impose an employer mandate, then that sets another standard. And in the minds of people now, they think it's an entitlement that goes with a job. And I think that's a mistake. I think it saps some of our vitality. But I wanted to take this down to the constitutional aspect of it. And just noticing that we had a law professor here, Mr. Joss, tonight, that's the part that grates on me the worst. We can talk about policy all day long. I've drawn my conclusions on that, and I've also drawn them on the constitutional side of this. But I just take it down to the individual mandate rather than the employer mandate side of this, and ask this question: if the federal government can constitutionally commandeer a portion of a person's paycheck, or a portion of the revenue of an employer for that matter, if they can commandeer that and assign it to a government-produced or a government-approved product, which is premiums for health insurance that is approved by the federal government, then what limitation would there be on the commandeering of that revenue stream beyond health care? Is there a constitutional line here I don't understand, or could it also be for a car, an appliance, buying certain types of health food, or a membership in a health clinic, or perhaps a gymnasium? Where is there a constitutional line beyond that? If the Supreme Court rules in favor and upholds this bill, this act, this law of the land, as Mr. Altmaier referred, I believe, if they do that, what then can the rest of the workers and the employers in America look forward to being commandeered? Where's the line?
Well, again, I only have 5 minutes rather than 5 hours, probably rather less than that. And I would refer you to the excellent opinion on this topic written by Judge Sutton of the 6th District, a very well-known conservative judge who's in fact been prominently mentioned as a Supreme Court potential nominee. And what Judge Sutton said, and what the other federal judges, several federal judges, the majority of the federal judges who have considered this question have said in favor of the constitutionality of the statute, and where I believe the Supreme Court will come down, is that Article 1 of the Constitution, Congress has the authority to regulate commerce. Under earlier decisions, Congress must regulate economic decisions. It cannot regulate non-economic conduct. But what Judge Sutton and what the other federal judges have found is that the healthcare marketplace and the health insurance marketplace are interstate commerce. In fact, it's the largest sector of our economy, and that Congress.
Excuse me, Mr. Jost. If an individual doesn't engage in purchasing health insurance, then they're not engaging in interstate commerce with the purchase of health insurance. And if you expand the argument to utilizing health care services, if an individual is born and dies in a state and doesn't cross a state line and doesn't use medical care of any kind, and that happens, it's always happened to every generation, how is it that they're engaging de facto in interstate commerce?
Well, what Judge Sutton said is, on its face, the statute is constitutional. As applied, there may be some situation where somebody will come forward who says, I have never used health care in my life, I will never use health care in my life, I can prove it, the law should not apply to me, and he said that might be a different case. We'll cross that bridge when we come to it.
I think we have come to it, actually. I think we have come to it, because the Constitution's got to apply to everybody.
Right, but a statute, the first question is, has Congress written a statute that is facially constitutional? Could it be constitutional as applied to some people? And as applied to 99.99999% of the population, people use health care.
Let me say that the statute presumes that everyone does use health care, and it presumes that health insurance is an obligation that's a component of health care. And if it presumes that everyone is utilizing, then the constitutional rights of those who do not are directly then incorporated into that. So they don't have their constitutional rights unless they assert them. We have to pass legislation that constitutionally protects everyone. That's the point I would make. I went way past my time. I'm sorry, but I appreciate the indulgence, and I yield back the balance of my time.
Thank you. That was a very interesting exchange. So I appreciate that question and that the line of questioning. I think those are definitely some of those issues that as we move forward that really does need to be discussed. So even though we went over, I can say it's all right. So. Did you have any other questions at this time? And Mr. Altmaier, do you have any? I have a couple more questions that I would like to ask, starting with Dr. Holtz-Aiken. You have said in the healthcare law, it is a threat to the healthcare of small business, or excuse me, the health of small businesses, and the mandates and penalties are a financial burden. Do you think small firms disproportionately affected by the various mandates, penalties, and taxes in the law? Will this affect their ability to increase employee wages, purchase new equipment, and hire new workers?
Absolutely. If you think of the smallest of the small businesses, the proponents of the law like to say, well, look, they get the credit and they're exempt from the mandate, and so it's all going to be good. But the reality is they will face the upward premium pressures that inevitably come from the benefit mandates that have already begun to be implemented and which are driving premiums up, the taxes that will be imposed on insurers, medical device companies, and others, which will inevitably drive. In my written testimony, I walk through the arithmetic of this. I mean, this is $5,000 for a family over the next 10 years. This is sort of real big impacts on the cost of health insurance. Every time those premiums go up, they come up at the expense of wages. There's no way around that. So even for those who are ostensibly spared the greatest regulatory burden, the greatest compliance cost burden, and even where temporarily help, although I'm not a fan of the structure of that credit, is available, I think it's on balance a bad deal.
Okay, thank you. Mr. Vaughn, I have a question for you. You currently have 30 full-time employees, is that correct? And a number of part-time employees, so 30 full-time and a number of part-time. With the employer mandate in the healthcare law, is it likely that you will create any additional full-time positions?
Well, as I mentioned earlier, it's not likely. It's likely that I'll cut to fewer full-time positions. You know, it's interesting about what Mr. Larson said earlier. The tax credit, I mean, look, I'm not going to participate in this certainly without tax-preferred dollars. He talked about, what was it, 9 employees or less or some ridiculous number, and those are the only people who are going to get a tax credit. So this thing is extreme. Mr. Joe said earlier that, the large firms, they're not worried about it. It's probably not even on their radar screen. That's just the cost of doing business for them. But again, it's clearly, in my case, going to create more part-time jobs, and frankly, people more dependent on the government, and I will be cutting even more jobs. So,
do you feel you may have to cut wages also, especially now, of course, with we have minimum wage, but as far as like potential increases in wages, do you think you may have to draw back on that as well?
I think so. I think, obviously someone mentioned earlier that wages should be absolutely should be a function of competition in the market. And I think that those of us that are in this business, we're all pretty much in the same situation. We're in a pennies business, and our margins, I mean, literally, if we said this thing about Burger King, and people look at us as very wealthy and very rich. Out of $1, we keep less than a dime at the end of the day, and so there's just no way we could afford this. Absolutely not.
Okay, thank you, Mr. Vaughn. And my last question. I have 2 questions, actually, for Professor Jost. If the forthcoming mandate's minimum essential benefit package requires employers to offer a base amount of coverage, that package will undoubtedly exceed the coverage that the small businesses currently offer. Aren't the premiums likely to increase for the employer or the individual or both?
I'd like to refer to a study that was published last month by the Urban Institute, in which they projected that the firms for small employers average employer contribution per person covered would in fact decrease by 7.4% after the Affordable Care Act is fully implemented. And the reason for that is the exchanges. Right now, small employers have to deal with individual insurance companies, and they don't have the economies of scale large employers do. They often have risk pools that are less favorable than large employers, and they're on their own. And even if they get a good rate this year, they could be canceled next year, or they could get a higher rate next year. In the exchanges, their business is going to be pooled with the business of all of the other small employers, and there's going to be lots of competition in the exchanges. There's going to be national insurers as well as the domestic insurers, maybe some of these new cooperatives that they're going to be talking about today, and so the projection is that in fact costs will go down. Now, with respect to the essential benefits package in particular, I'd always assumed that small businesses provide less rich benefits than large businesses, but I tried to check on that the other day and found out that, in fact, if you look at the National Compensation Survey, the benefits are pretty much comparable. They cover pretty much the same things. And the reason, again, is because of the state mandates that require in many states employers to cover a lot of the same benefits, insured employers. So the essential benefits package only covers benefits. It doesn't prescribe cost sharing. Right now, a lot of the gain is in trying to increase cost sharing in various ways. That's probably one of the reasons why healthcare costs are going down, because employees have more skin in the game. And I think that under the essential benefits package, number one, it isn't going to change that much what the benefits employers are going to have to offer, and number two, they'll still have the ability to do considerable adjustment in the cost sharing to try to save costs.
Can you just describe to me the difference? You mentioned national insurers and domestic insurers.
Mm-hmm.
Can you identify for us what you mean by that?
Yeah. Under the Affordable Care Act, the Office of Personnel Management is supposed to come up with at least two, maybe more, national multi-state insurance plans that will be available in every state. It's going to be like the insurance you have, Congresswoman, where through the Federal Employees Health Benefit Package, where you have a choice of national insurers as well as local HMOs or other small carriers at the state level. And that's going to introduce more competition into the insurance market. Again, I've been looking at all these adjustment requests as they come through, and what you see is that in many states you have what you have in my market, where you have one insurer with 85% of the market. Well, they set the price. Nobody else really can can compete with them. But we're going to see a number of insurers competing, and competition brings down prices.
And so can you describe to me then when the domestic insurers?
Well, by that I meant insurers that are already there, that are licensed in the state.
And when you describe the national, are those private insurance companies, or would that be the government plan?
No, they have to be private insurance companies. They have to be a company licensed in the state. Okay,
well, thank you all so much for your participation. Yeah, I had asked a moment before I asked my question. So, but if you did have another question, I'm more than welcome to. We will definitely approach that. This subcommittee will continue to closely follow the issues related to this implementation of the health care law. It's very, very important that we stay on top of this as it moves forward, especially since things seem to be evolving as we go along. I ask unanimous consent that 3 articles be submitted for the hearing record. An article from Crane's New York Business dated June 23rd, 2011, entitled Health Reforms, Grandfathering Rules Likely to Raise Costs. An article from Forbes dated July 4th, 2011, entitled Healthcare Tax Credits Are Having a Minuscule Impact. And an article from The Hill, which I had mentioned earlier, dated July 21st, 2011, entitled Healthcare Law Could Leave Families with High Healthcare Costs. Without objection, so ordered. All those in favor signify by saying aye. All those opposed signify by saying nay. The The ayes have it. The request is agreed to. And I ask unanimous consent that members have 5 legislative days to submit statements and supporting materials for the record. Without objection, so ordered. This hearing is now adjourned. Thank you so much.